uh, we have everyone involved, I think, on this case to go. Mr. Lusk, I believe you represent the appellant in this case. Is that correct?
Yes, Judge.
And did you like to reserve any time?
2 minutes should be sufficient. Thank you, Judge.
Okay. And I assume Counsel Gonzalez and Bellis will be dividing the time for the appellee?
Yes, Your Honor.
Okay. Who will be going first?
I will.
Then I will let you tell me then how it's going to be divided. So as an old person, I don't lose that piece of information.
All right.
Mr. Lusk, you have the floor, sir.
Thank you, Your Honor. The first issue I'd like to address is I believe that the trial court applied the wrong legal standard for negligent infliction of emotional distress. So there's a division as to whether or not what law to apply based on whether the individual plaintiff has sustained an impact versus a non-impact, what we refer to as bystander cases. And this point, I'd like to basically reference Willis v. Gammy Golden Glades case, 967 Southern 2nd, 846. And it quotes the standard as this. It says, in Florida, the prerequisites for recovery for negligent infliction of emotional distress differ depending on whether the plaintiff has or has not suffered a physical impact from an external force. If the plaintiff has suffered an impact, Florida courts permit the recovery from emotional distress stemming from the incident during which the impact occurred and not merely the impact itself. And so,
Mr. Lusk, could you help me out here?
yes, sir.
It's been a while since I presided over a PI trial. Your client was involved in a car accident. There was negligence involved and he was injured. Would one of his compensable injuries be mental pain and suffering that he would have sustained? And if so, would that include the horror of watching loved ones being hurt in the same accident?
My understanding is yes, Judge, because he sustained an impact. So that claim should be included as part of his emotional distress damages.
Okay. And the argument here is that he was not allowed to pursue this award?
Exactly, Judge.
Okay, just wanted to be sure I was on the same grounds as everybody else. Thank you.
So essentially the court applied the bystander case. So for Your Honor, he was the driver of the vehicle, and then he also had passengers in the vehicle. And so his fiance,
I guess fiance and the young boy was in the back seat.
Correct, Judge. And so she was paralyzed. The young child was sustained, minor injuries as well. So he has negligent infliction of emotional distress claims for both of those. But he suffered an impact in this case. And the Florida Supreme Court in that Willis case defines what an impact is. It says an outside force or substance, no matter how large or small, visible or invisible, and no matter that the effects are not immediately deleterious, touch or enter the plaintiff's body. And so clearly, one of the cases is, an individual that is robbed and had a gun pointed to their temple and then received a pat down. So a dangerous instrumentality, such as a motor vehicle, certainly qualifies as an impact in this case. And so the court should have never applied the bystander exceptions to this case, which it did. And I'd specifically refer to former Chief Justice Lewis's concurring opinion. He goes through a wonderful historical analysis of all the case law precedent and the distinction of when you apply the bystander exceptions to the impact rule versus impact cases. And so just a wonderful concurring opinion from him. He actually, in the concurring opinion, complimented the second DCA's opinion in Rivers v. Grimsley Oil. And he says that the district court made it clear that in that case, there was no impact, so we applied the exceptions to the impact rule. But then in the footnote, it says, it is interesting to note, however, if the plaintiff's claim did involve a physical impact, it would almost certainly be a claim. And so he does recognize that. However, even if we're applying the exceptions to the impact rule and we're saying this is not an impact case, which clearly it is, the plaintiff met those additional elements. And so the trial court applied the non-impact bystander elements to this case, and he excluded any negligent infliction of emotional distress stemming from the plaintiff's sensory perception of Rosa Miranda, who's the back left seat passenger that was paralyzed in this incident. And he did it on the basis that she did not have a legal relationship with the plaintiff. And that is incorrect because that is a factual issue. And so I have that case specifically is Waters v. Walgreen Company, 967 Southern 2nd 930. It's a first DCA 2007 case. And it held that the trial court erred when it entered summary judgment on the sole basis that their lack of legal relationship barred their claim as a matter of law. And that case does a great job analyzing the seminal cases, which is the seminal case is Champion v. Gray, but then it's further expounded upon in Zell v. Meek. So Zell v. Meek is the real one that talks about this relationship component. But the Waters case in the first DCA analyzes Zell v. Meek and does a great job in that case. Now, the defense, I want to talk about the defense cited another case, which is this Reynolds v. State Farm, 611 Southern 2nd 1294. The problem with that case is that case was 1993. It came out before Zell v. Meek. It came out, the Waters case directly contradicts it after Zell v. Meek because it had the benefit of learning the Supreme Court's opinion on this. And that case is wrong on two counts. Number one is they applied the wrong standard because that's an auto case with an impact, and they applied the non-impact exceptions to that case. And then they also said that it required a legal relationship, which it doesn't. That was a fiance case. So that Reynolds case is just old case law that has not been updated and quite honestly is just should be revisited in light of Zell v. Meek and Waters v. Walgreen Co. And that's also reflected in the notes for use on Florida standard jury instructions. So for the non-impact bystander cases, it explicitly says Florida standard jury instruction 420, if the plaintiff has suffered an impact of any type, do not apply these elements. And then it cites Waters. So this has been adopted by the instructions as well. The second issue is now, so that was Rosa. So Rosa was excluded because she didn't meet, because the court applied the wrong standard. And then they said that she didn't have a close legal relationship, but that's a factual issue. So summary judgment should not have been granted there. The second issue is then Joshua, which is the minor child. The court said that Joshua did not sustain a sufficient threshold of injury in order to qualify for the negligent infliction of emotional distress. And my comment to this was, yes, Judge, this may not be as significant of a claim, but it still is a claim, and that it's something that just can't be broken out. So I don't know the court's basis for excluding his minor son, because clearly they did have a legal relationship in that case, in that instance. So the third one, and this is where the case law is actually the most clear. So if there's one clear-cut issue, it's the trial court's exclusion of plaintiff's treating psychiatrist, excluding her testimony in its entirety, not just future medical care. He excluded Dr. Miriam Aho's testimony in its entirety. And here's what he said. He said that it is excluded in its entirety because her opinions were not given within a reasonable degree of medical probability. I have the answer to that rationale. And this is the Florida Supreme Court case, Gutierrez v. Vargas, 239 SO3D 615. This is a Florida Supreme Court 2018 case. It goes in depth explaining the difference between a hired expert versus a treating physician. And here's what it says in pertinent part. It says a treating physician, and I'll just make this distinction real quick. I had also hired an expert psychiatrist to give expert legal opinions. This was a psychiatrist that was just treating. So I'm only asking her about, what did he tell you? What did you do? What did you prescribe? All your medical treatment that you rendered. And here's what it says regarding a treating physician. It says a treating physician is a fact witness and testifies to past facts based on personal knowledge. Those facts involves a technical matter about which the jury lacks basic knowledge, but are facts nonetheless. The treating physician's perception of the plaintiff's symptoms, their diagnosis, excluding the treating psychiatrist in its entirety. I think there's clear case law against that position. The next one I wanted to touch on briefly was the exclusion of all future medical care for Dr. Acosta. So Dr. Acosta was the back doctor that gave injections to the plaintiff appellant in this case. And here's something that's been coming up from a practitioner's standpoint. I almost have a practitioner's plea for the court. Ever since the True Love case, and then we had that subsequent case of Geico v. DeGrandchamp from the second DCA, that one's 102 SO3D 685. It's a Florida second DCA 2012 case. The standard has been that you have to set forth what's reasonably certain to occur in the future. And so what's been happening is every time the defense rests their case, they move for directed verdict saying that, oh, the doctor didn't say within a reasonable degree of medical certainty. He only said within a reasonable degree of medical probability. And it confuses the courts. And that's why the trial court said in this case, he's like, well, he only said reasonable degree of medical probability. He didn't say certainty. He didn't use the magic words. And I tried to explain to the court, I said, well, it's greater weight of the evidence, right? It's preponderance of the evidence. That is probability. And that goes for all facets, past medicals, future medicals. You don't increase the standard to certainty just because that's the language that was used in the case. And so in the Geico v. DeGrandchamp case, fortunately, the second DCA quotes, it is the plaintiff's burden to establish that future medical expenses will more probably than not be incurred. And so when Dr. Acosta says, yes, the plaintiff will probably need X, Y, and Z treatment, that still meets the burden. He doesn't have to say within a reasonable degree of medical certainty. He can say within a reasonable degree of medical probability and be sufficient testimony. And I actually have that exchange as to how he meets that criteria if the court would like to meet it. But basically it's type, frequency, and cost. What type of medical treatment, how often do they need it, and what's the cost? He said 4 injection sessions per year through the plaintiff's life expectancy, which we provided a mortality table, and he said at a cost of $14.05 per injection session. And so there is a reasonable evidentiary basis where the jury could award future medical care for the injections that was improperly excluded. The last issue I wanted to address is the trial court excluded on a last-minute motion in limine from the defense the testimony in its entirety of the defendant driver. So the defendant driver was driving a Snap-on work truck. Liability was admitted, and so they admitted they negligently operated a motor vehicle. Causation and damages. And so if you're still disputing causation and damages, I can still call the defendant driver and say, how fast were you going? Tell me about the force of impact. Tell me about the impact orientation on the vehicles. Where did you hit them? He actually hit the back left and then rolled over their vehicle. Nobody is in a better position to know these answers than the defendant driver. And so by the trial court not even allowing me to call the defendant driver at trial, did not give any testimony that was sufficient regarding force of impact and causation and damages, which we were still trying in this case. And then the other one he excluded was the front seat passenger. He said the front seat passenger cannot testify about anything regarding the impact of this vehicle and is only limited as incapacity as a before and after witness. Well, Mr. Duarte, the plaintiff, was knocked unconscious as a result of this impact. And so the front seat passenger would then be the second best witness to say, yes, I saw the biomechanics of him getting knocked forward, his head hitting the steering wheel, him getting knocked out, whatever injuries he sustained. So that's eyewitness testimony that I then could not bring in and talk about because the court excluded that testimony as well. And so for these reasons, as well as the brief, we'd ask that the court reverse.
Thank you, counsel.
Thank you.
Attorney Gonzalez, if you would tell me what the time frame is that counsel will be utilizing.
Good morning, Your Honors. May it please the court, Lisa Gonzalez on behalf of the appellee Snap-on. Ms. Bellis and I would like to split our time equally, if that's okay.
10 minutes per.
Yes.
I will let you know when you arrive at 10.
Okay. I will be addressing the issues related to summary judgment and any sort of smaller pretrial rulings, and Ms. Bellis will be addressing the issues related to the trial itself. So if I may proceed with regard to summary judgment, um, there are sort of two arguments here, or the argument is sort of twofold with regard to NIED. The NIED claims were properly disposed of on summary judgment because, number one, having suffered an impact in the accident, Mr. Duarte was not entitled to raise a separate NIED claim. His emotional distress claims were part of his direct negligence.
So that goes back to my original question. He was allowed to seek damages for whatever trauma he alleged he sustained emotionally as a part of his direct involvement in the accident. Is that correct? Is that your position?
That is correct. There isn't a need for a separate or independent NIED claim in circumstances such as these. The emotional distress is a part of that claim, and everything that Mr. Duarte witnessed, everything that occurred during the collision, is a part of that claim. And he, in that regard, he was certainly not hindered from presenting his emotional distress claims to the jury. He actively prosecuted the claim. There was extensive evidence in this regard. The jury was told as part of the emotional distress claim that the girlfriend was in the car, the son was in the car, that they were transported to the hospital. What was left out were the details or the specifics of Miss Miranda's injuries, which were irrelevant for him to establish his own injuries or his own damages. And then the second part of that argument, if I may, is if he is allowed to bring a separate NIED claim, he certainly has to be able to establish some showing of entitlement to that claim. At minimum, a discernible physical injury that's directly related to having witnessed Miss Miranda's injuries. And now, excuse me for just one moment. So he claimed various injuries that were allegedly arising out of this psychological trauma, some purely psychological, some were mere exacerbations of previous medical conditions, and a couple of other injuries, which included exacerbation of diabetes and hypertension, some nausea, sleep disturbance, things of the sort. There's a number of cases that go through these various injuries and find them to be insufficient to satisfy the impact rule. But I think more importantly, there isn't much of a difference between the injuries that they were claiming with regard to his injuries in the accident and those resulting from the alleged PTSD. It was nearly impossible to parse these injuries out for the sake of awarding damages in a way that wouldn't overlap or create a sort of double recovery for the plaintiff. So for example, they argued that Mr. Duarte suffered from back pain. He had some trouble taking care of Miss Miranda post-accident, and that caused him stress and anxiety. So how then do we distinguish this stress and anxiety that's caused by his injuries in the accident from the stress and anxiety that he's alleging he suffered as a result of having witnessed Miss Miranda be injured? So that brings us back to the original point, which is you cannot have these two claims. These two claims shouldn't coexist. They are two distinct legal concepts. And again, he wasn't hindered from establishing his emotional distress claim. He was able to do that. So that is all I have on that issue. If I can briefly just address Miss Miranda's injuries. Miss Miranda's injuries was really the only thing that when the NIED claim is disallowed at the summary judgment phase, he's not allowed to discuss Miss Miranda's injuries. Miss Miranda's injuries are not relevant for him to be able to establish his claim. And they were much more serious. Unfortunately, she was involved in a bit of an accident within an accident where the impact itself wasn't the rest of the passengers weren't as severely injured as Miss Miranda was. And throughout the entirety of the proceedings, Mr. Duarte attempted through various ways to try to get this information and seemingly to try to bolster his own claims, which were relatively minimal by comparison. But the extent of her injuries didn't have to be discussed in order for them to say he perceived this. I was there. I was emotionally impacted as a result. And he was able to do that. Again, I just want to sort of emphasize that he was able to do that. He actively prosecuted these claims. He presented extensive testimony in this regard. The only thing that was left out was the extent of her injuries, which were irrelevant. And any marginal relevance was certainly outweighed substantially by the danger of prejudice to the defense, of having that come in and having the jury make a comparison or a correlation between their injuries, which were really irreconcilable. And I don't believe I have any other points to address. If your honors don't have any questions for me, I think I will rest on our briefs and ask that this court affirm.
Thank you, counsel.
May it please the court. Karen Bellis of Kubicki Draper for the
Don,
defendant.
you want to give me a chance to clear your time, unless you want to start at where she was at. That might restrict your ability to present.
I apologize.
That's all right. You know, I'm learning my technological skills as we go. You are ready to go. Thank you.
Karen Bellis of Kubicki Draper for the defendant, Norman Mullins. And I apologize in advance if I start coughing. Hopefully I won't, but I'm getting over the plague. I would like to address some of the evidentiary and trial issues that the plaintiff has raised here. Again, these were abuse of discretion issues that we framed in the brief, none of which require a new trial. But since the negligent infliction of emotional distress claim was also an issue at trial, and one that Your Honor, Judge Questoreva just commented about, I wanted to bring one thing to the court's attention. The jury instructions and the verdict form specifically ask the jury to, if they find a permanent injury, to award pain and suffering, physical impairment, mental anguish, the traditional damages that were allowed to be presented as part of his negligent claim. They went to the jury and the verdict form, and the jury did not believe that plaintiff suffered those injuries. With regard to the trial issues, I think it's important to note the history of the case and how we got here. What happened, and there was a prior decision in this case written by Your Honor, Judge LaRose, on a dismissal for fraud. This was an admitted liability case, which goes to the admission of Mr. Mullis's testimony that we'll talk about. It was also admitted rear end, admitted that the defendant was intoxicated. It's important to note, again, how we got here. The plaintiff has almost no treatment for 4 years. This trial is 12 years post-accident, and only following a very similar 2012 rear-end accident that the plaintiff, again, the first opinion and much of this trial, fails to tell his doctors about, fails to disclose on the forms, fails to tell the truth. He does not see a psychiatrist for 5 years after this 2008 post-2012 accident. And he doesn't see the primary who testifies at trial for 7 years after this accident, again, post the 2012 accident that he fails to disclose. So many of the issues that we're deal with, and much of the evidence, dealt with plaintiff's credibility, impeachment evidence. But despite this, and despite plaintiff's claims here, many of the doctor's opinions were that the plaintiff suffered permanent injury, including emotional injury, that he needed future care, but they did not believe him, which is why they awarded only his past medicals, but found no permanent injury and awarded no mental anguish. So if I turn then specifically to the exclusion that's been raised in plaintiff's briefing here today of Dr. Ahill's testimony. Again, she was a treating psychiatrist, and despite what the plaintiff has said here, and despite a little bit of a confusing discussion at trial and the rulings, Dr. Ahill's testimony in full, her opinions, and all of her medical records came in at trial, so much so that they're actually quoted in both parties' briefs. So Plaintiff actually concedes with regard to Dr. Accio that she does not talk about future care within a reasonable degree of medical probability. So there's not going to be any damage, any objection from me, this is the plaintiff, as to her future care. The quote goes on to say, she says she will need it, but she does not meet the standard for future medical care. This is at page 296 to 935, excuse me, not 926 to 935 of the trial. So the initial motion is to exclude any testimony from her as to future medicals, which plaintiff concedes. The Gutierrez case that the plaintiff cites here is not dispositive. That is just a discussion of the difference between an expert and a fact witness in the context of multiple cumulative witnesses, but that is not dispositive. Instead, what is dispositive here is that the jury actually receives, as I said, all of her medical testimony, her evidence, her diagnosis, and her treatment through not only her full medical records that come into plaintiff, but through Dr. Hall, plaintiff's expert psychiatrist, who testifies that the plaintiff has chronic adjustment disorder, will need essentially to be admitted into a facility for a long time, some type of care that will take months and a month and cost $35,000 or something. That comes in, future comes in, and the diagnosis of chronic adjustment disorder. Both Dr. Hall and the defense doctor, Dr. Raphael, both rely on Dr. Aho extensively, her conclusions, her records, they talk about the symptoms. The quote on our brief at page 20, again, is actually the medical records admitted of Dr. Aho that are used by everyone else and that are in the record at page 27, 26, 27, 27. They go to the jury where they describe the flashbacks, the distress, that he's got PTSD, that he's taking Zoloft. So all of this actually comes in. And so though the ruling is a little, starts off as something else and then becomes that she's fully excluded, she's actually not. And the effect of the ruling and limitation only acts to keep out from the jury, which is proper under true love and is conceded here, to be proper under de Grandchamp and true love, for her opinions on future medical care. So that's a non-starter. Turning then to issue 4, which is the limitation on Dr. Acosta. Again, the trial court did not abuse its discretion on this limitation because what was limited were the future medical expenses. We know that de Grandchamp and True Love case that medical expenses that are not testified to be reasonably certain in the future cannot be recovered. Again, page 677 and to 78, and our answer brief at 24 to 26 quotes extensively what this doctor says. There is no testimony that meets the test. The doctor says, it would be likely, my likely recommendation. It is difficult to predict. It might vary depending on the levels. It's not uncommon to get that treatment, but that's not medical certainty. He might require occasional interventions by injections, but this possibility, the quotes again are lengthy. They are not enough to get to those tests under true love. With regard to the $1,400 or so of the costs, the joint case out of the Florida Supreme Court says that the past expense, which is what, again, after some give and take and uncertainty, this doctor looks to one of his old bills and says, I have an old bill from June, it's $1,400. Joint and some of the other cases hold that the past expenses themselves are not enough to establish the future costs. Then he recedes even further on cross-examination when talking about diabetes, the heart attack, the accidents, and some other medical issues of the plaintiff. And he further recedes and says, it's not unreasonable that I won't be able to have injections because of his other medical care. So again, no reasonable certainty, doesn't meet those legal tests, no direct evidence of cost. That can't come in. Again, with regard to the futures, there are other doctors. It goes to the jury through Dr. Hall. It actually goes to the jury, future medical evidence and permanency from the internal medicine doctor, Gallo Bello, as well as to the cardiologist, Dr. Guerrero. But what happened? The jury didn't believe this because of a variety of other untruths that the plaintiff told. So during the next issue, the trial court did not abuse its discretion in limiting the prejudicial, cumulative, and irrelevant witnesses. This is issue 5, and here there were 3 witnesses that the plaintiff addressed. First, Mr. Mullins, and the issue of Mr. Mullins being excluded, the case law is extremely clear. Case law cited in both of the appellee's briefs, Metropolitan-Dade County, TT versus Forston, the Hurtado case, in an admitted liability case, especially one where there's intoxication, and where the plaintiff has memory issues. The testimony of the defendant driver would be prejudicial, is irrelevant, and would have served no purpose, to the extent that the plaintiff argues that he was limited in presenting force. If he wanted to present force testimony, he could have done it through an accident reconstructionist, and he actually did it through multiple other witnesses. The plaintiff talked about being in the accident a force like no other. There were 2 eyewitnesses in another car, Glenn Campbell and Stephen Clifford. Photographs of the accident came in through those witnesses, as did the fact the plaintiff didn't put on his brake, the defendant didn't brake, the defendant was speeding, that the defendant's truck goes over the plaintiff's car. All of this came in through multiple other witnesses. So again, with the liability case being admitted, Mr. Mullins' opinion on these things, especially since he has memory issues and actually passed out, would have been not only cumulative, prejudicial, and irrelevant. Turning to the grandson, Adele Duarte. Again, cumulative, irrelevant, not an expert. We had 2 eyewitnesses. We had the photographs. So Adele did testify, the grandson, but he was allowed to testify about his grandfather and as a before and after witness, again, going back to the mental anguish coming in and the other damages that did come in and went to the jury that the jury did not believe. And actually at page 400, the plaintiff admits that Adele's testimony on the issue of the actual accident would have been cumulative. My co-counsel, if the court has no questions, dealt with the exclusion of Rosa live and the exclusion of her injuries. So I think we've dealt with that. Again, it would have been prejudicial. The plaintiff also, I would add, there was a discussion at trial about the ability to have her come by live feed, which nowadays, I mean, this is just a year ago, it wasn't quite happening yet, but now we know this happens quite frequently. And to the extent that the plaintiff claims there was a due process issue, by the jury not being able to ask questions or see this witness live, there was a discussion of live feed. Plaintiff chose not to do that. Instead, plaintiff chose to put on this witness by prior video deposition, the same as he did with actually 8 other witnesses at this trial. I believe that's turning to the very last issue, actually, if I have time, the impeachment testimony. There was no abuse of discretion. And the same with the very brief mention of insurance, which actually came up in the earlier case. With regard to the impeachment issue that plaintiff raises on issue 6, this was a questionnaire that the plaintiff failed to complete honestly for Dr. Hall. As I've said, and as the briefs describe, and as the prior opinion describes, the credibility of the plaintiff, the fraud, the throwing out of his tests by experts because of the LIE lie being so high that they can't rely on them, that he didn't distinguish between the 2008 and tell about the 2012 tests, as well as 4 divorces, foreclosures, and lots of other things that were going on in his personal life. The focus, much of the focus, and what happened with the jury, is that he spends a day with Dr. Hall. Dr. Hall reviews all of the records, including Dr. Ajo, that comes in through him. And plaintiff fills out a long questionnaire in Mr. Lusk's office, where he fails to disclose prior lawsuits. One of those is another lawsuit filed by Mr. Lusk 3 months earlier. So it's just a credibility issue. Again, is one mention of it. The first page of the lawsuit to establish the lie, the failure to disclose, is all that comes in. So at most it's harmless, especially combined with all of the other falsehoods in this case. And then finally, the brief mention of insurance does not require a reversal here. I would also mention it wasn't raised, there was no motion for new trial. So none of this, to the extent that the trial court should have been given another opportunity to look at any evidentiary issues, and that we're talking about abusing the discretion, and there wasn't an opportunity for a new trial. But the brief mention of insurance is not a reversible error. It came in during the video of Dr. Raphael. Dr. Raphael was talking about radio frequency blocks, and he said something about the healthcare treatment. You can't even get approval for those unless you do 2 of them and they get a positive result. You get 2 successful results. He's talking about health insurance, not the defendant's insurance, not that a liability insurer would pay. There's plenty of case law that one passing mention is not enough. And it's also waived because the plaintiff chose to play, well, the parties chose to play Dr. Raphael is actually our expert by video. Beforehand, we went through a page and line excluding the various things that people didn't want to come in, that the parties didn't want to come in. So the plaintiff could have chosen to keep out this mere mention. It wasn't raised. And so it's actually invited error and harmless error. And so there's no reversible error.
I need to let you know the full 14 minutes that you inherited time from Attorney Gonzalez has expired.
Thank you. Then I will just wrap up and conclude, which is there is no abuse of discretion, no reversible error, and we would ask the court to affirm the jury verdict and the final judgment.
Thank you, counsel. We're going to pause for a moment because I see Judge LaRose is not here with us right now, at least in video format. He may be here in audio, and they are checking on that. So before we go to Mr. Lusk's rebuttal, let us see if we can find him. Come on, technology. Yay! Our favorite judge is back.
I just had a technical glitch here with my screen. Sorry.
That's all right. Did not want to keep going until we knew. All right. Mr. Lusk, you did not use all of your time before, so I don't know if you still want to be limited to your 2 minutes, or would you rather have the maximum of 5? Not going to cause you to forfeit it anyway, is what I'm trying to say.
Okay, yeah, I'll just take whatever the court allows. But I was actually thinking about Your Honor's question, so since there's an impact, wouldn't he be able to bring emotional distress damages in his direct negligence claim? Because if there's an impact, you get emotional distress and mental anguish from the entire incident. And so if that is accurate, and that there were concurring theories of liability, right, where he has direct negligence and he also has account for negligent infliction of emotional distress. Well, if the court excludes the negligent infliction of emotional distress, the court still erred because in his direct negligence count, part of the motion in limine was plaintiff cannot talk about any of his sensory perception of Rosa Miranda, any of his sensory perception of Joshua Duarte. So that would be an error in his direct negligence claim, because I couldn't even bring Rosa to court. Jurors could not ask her questions. He could not talk about any of her injuries. He could not talk about her caretaking. And this kind of goes to the point where the adequate picture was not painted, because
I'm not sure that if it goes to the first part, her caretaking is going to be part of that compensable injury. If he's in an accident and he sees her getting hurt and the car rolling over, I think everything that temporarily happens there with the child in the back might be within the scope of his mental injuries.
Okay.
And I'm not sure how that might be excluded or not, but that is, to me, something that's different from a standalone cause of action that seems to be alleged for the impact rule type of case. I think for the first one, you just have to meet, what is it, 627, 727, that you have a permanent injury, and then you can get pain and suffering and emotional distress. Again, as I mentioned before, it's been a while since I presided over a direct trial. So I'm trying to make sure that my old information is not entirely outdated.
Yes, that's accurate. The caretaking point was, so a big issue in the case is this delay in treatment. Well, you know, if he's in the hospital for 45 days after this incident by Rosa Miranda's side, and they're saying, well, why didn't you get medical treatment during that time? Well, yeah, because I'm in the hospital, you know, watching after my fiance that's in a coma. And then they said, in the year after this incident, okay, how was your life impacted? How was your life changed? Well, his whole life is now taking care of a paralyzed individual. So his physical limitations include lifting her out of the bed, bathing her with back injuries. And so none of that was able to be explained because Rosa Miranda was excluded entirely. He couldn't even talk about any sensory perception of her, which should have been brought in his general negligence claim, to your point. So that's all I have, Judge. Thank you. Oh, sorry, one more thing. Yes, back to this thing. If the court puts anything about reasonable degree of medical probability for future medical care, as opposed to reasonable certainty, that would save us so much trouble in every directed verdict. So I really appreciate your time. Thank you.
Thank you all.
Thank you.
Thank you.
Stay well, please.
All right.
You too.